Good evening, everybody. Welcome to Courtroom Insider, coming to you from Phoenix, Arizona, where it's not as hot as it has been in other days that I've been here. Still over 100 degrees. I'm Nate Eaton. Thanks for watching tonight. In just less than 12 hours, a little over 12 hours, I should say, Lori Vallow Daybell will be sentenced for the last time. This is the final chapter in a saga that has lasted 5.5 years. From multiple states, multiple law enforcement agencies, multiple investigations, it is winding down. And that is why we are here in Arizona. Thanks for watching tonight. Please let me know where you're watching from, and if you have any questions, we'll get to your questions at the end. Took off this morning from Idaho Falls, and look who happened to be on our flight. 3 of the detectives who played a pivotal role in this case the entire time: Lieutenant Hermosillo, Detective Considas, who has since retired from the police department in Rexburg, but he wanted to come and kind of see this to the end, and so did Detective Eric Wheeler. And not in this photo is Sheriff Ron Ball, who is the current sheriff of Madison County, but was working with the Rexburg Police Department when all of this happened. They are here. They will be in the courtroom tomorrow, as will several other people who were on our flight who just want to come for the hearing. We are expected to have several family members in court tomorrow. Of course, Kay Woodcock will be there. Larry Woodcock will be there. I'm hearing that other family members of Brandon Boudreau's will be there. And they will have a chance to read victim impact statements and speak to the court about how these crimes have affected them. So we'll get to that in just a minute. I do want to begin by taking a drink of water. Just one moment. It's quite dry here. Some court documents that have come out that I haven't had a chance to review with you. It has been a busy week of trials. Brian Koberger, of course, yesterday, and so we've been following some other things. But the prosecutor has issued their sentencing memorandum. This is where they send it to the judge, Lori Vallow, on these charges. So let me back up if you're brand new here. She has been found guilty of 2 counts of conspiracy to commit murder, first-degree murder. And these counts involve the death of her 4th husband, Charles Vallow, and the death of her, the attempted murder, I should say, of her former nephew-in-law, Brandon Boudreau. Separate trials were held just a few months ago. Different juries found her guilty in both trials. The minimum penalty she could face on these is 25 years. The maximum penalty she could face is life. These sentences could run concurrent, meaning at the same time, or consecutive, meaning one after the other. Does it really matter? Yes, it matters. But regardless of what she's sentenced to tomorrow, she will head back to Idaho probably within a week. I would imagine they'll move her quite quickly. And she will serve her sentence in Idaho. And then she's going to serve life in prison, no parole. But should somehow that case get turned over on appeal, the Arizona sentences then take effect. So regardless, she's locked up forever. But this will be officially on her criminal record in history, whatever the sentence is she gets tomorrow. So she could face 25 years to life on each charge. The prosecutor sent a memorandum to Judge Justin Boreski. And in this memorandum, Trina Kay summarizes the facts. She says, on January 30th, 2019, Charles Vallow called the Gilbert Police Department to report that the defendant believed he was Ed Schneider, that she was going to murder Ed Schneider, and that she was going to destroy him. This was the beginning of Charles Vallow's nightmare, from which he was never able to wake. On January 31st, 2019, he reported his concerns to the Gilbert Police Department about the defendant's beliefs. He is recorded on body-worn camera video telling the police that the defendant threatened to murder him, that the defendant said that Charles was dark, and she was calling him by someone else's name. Charles Vallow told the police that his wife believed she was a translated being and she couldn't die. Charles explained to the Gilbert Police Department that he was concerned for his children and that he did not know what she might do to them. Charles told the police that the defendant told him to come get the kids and that she did not care what happened to them. Charles had sole custody of J.J. Vallow from the time the defendant disappeared in February of 2019 until April of 2019, when the defendant came back into their lives. Charles invited the defendant and Tylee Ryan to live with J.J. and him in Texas. When the defendant wanted to move to Arizona, back to Arizona, Charles rented a house in Chandler, Arizona for her. Charles moved the defendant, J.J. and Tylee into the home on Four Peaks, at the end of June of 2019. Charles remained in Texas. Then, July 9th, 2019, Charles books Adam Cox a flight to Arizona to help him with an intervention to try to get Lori Vallow back into the traditional LDS beliefs. A few minutes after Charles booked this flight, Adam Cox called his brother Alex and let him know he'd be in town on the 10th and wanted to stay with him. On the evening of the 9th, Lori Vallow told her brother Alex, quote, "It's all coming to a head this week. I will be like Nephi, I am told, and so will you." After this text, the defendant and Alex Cox spoke on the phone for 56 minutes. The evening of July 10th, Alex Cox drove to the defendant's home with a gun and spent the night at the defendant's house. On July 11th, Lori Vallow's threats to kill Charles Vallow came true. Charles Vallow came to the house. He rented to pick up his son JJ. As Charles arrived, he saw Alex Cox's truck and he knew that Lori Vallow and her brother were planning something. The defendant allowed Charles to put JJ into the rental car, and then she took Charles's cell phone and refused to return it. Lori Vallow was able to keep Charles inside the house by refusing to give him back his cell phone. No matter how many times Charles demanded the defendant hand over the cell phone, the defendant would not give it back to him and instead walked around the house with the phone. As this defendant was holding onto Charles Vallow's cell phone, Alex Cox came out with his gun. Alex Cox shot Charles Vallow in the chest, causing him to fall to the floor. As he lay on the floor, Alex Cox shot him a second time in the abdomen. Lori Vallow left the scene in Charles Vallow's rental car, while Alex Cox stayed at the house and staged the scene. The defendant and Alex Cox waited approximately 47 minutes before calling 911. Later, the defendant and her brother went through Charles Vallow's cell phone before giving it to police. The day after Lori Vallow and Alex Cox killed Charles Vallow, Lori texted Charles Vallow's sons from his prior marriage and told them, "Hi boys, I have very sad news. Your dad passed away yesterday. I'm working on making arrangements and I'll keep you informed with what's going on. I'm still not sure how to handle things. Just want you to know that I love you and so did your dad." That was on a text. Trina K goes on to write to the judge, "The defendant's text messages to Charles Vallow's sons was not only distressing to them but devastating. Although the defendant said she would keep them informed on what was going on, when Charles's son asked what happened, the defendant responded, 'We are waiting for the ME report. I'll let you know more when I can.' Charles Vallow's sons repeatedly texted the defendant asking her what happened to their father and for information about the funeral. By the way, we have those texts. If you go to eastidahonews.com, I did a story 5 years ago, detailing those texts back and forth. The defendant would not tell Charles's sons what happened or provide any real information. When she did respond, the defendant acted like she did not know how Charles had died. Eventually, one of Charles's sons reached out to their aunt, Kay Woodcock, about the text message from Lori Vallow saying their dad was dead. Kay also had no idea that her brother, Charles Vallow, was dead. Kay and her husband, Larry, were able to verify Charles had been shot and killed by Googling his name. Kay Woodcock then had to tell her brother's sons that their dad had been shot and killed by their uncle, Alex. On July 15th, 2019, the defendant called Banner Life Insurance Company, claiming to be the beneficiary of Charles Vallow's $1 million life insurance policy. On July 18th, the defendant learned that Charles Vallow had had changed the beneficiary to his life insurance policy. On July 18th, the defendant messaged her soon-to-be husband, Chad Daybell, said, quote, "I talked to the life insurance company. He changed it in March. It was probably Ned before we got rid of him." Lori Vallow moved to Rexburg in August of 2019 to be closer to Chad. Lori Vallow could have allowed JJ to go live with Kay Woodcock, but instead she brought JJ and Tylee with her to Idaho. Alex Cox also moved to Rexburg in August of 2019. Tylee Ryan was last seen alive on September 8th, 2019 in a photograph from Yellowstone National Park. JJ Vallow was last seen alive on September 23rd in a video outside the defendant's apartment. The same day that JJ was last seen, Alex Cox began searching for places to practice shooting near Rexburg and for places to tint the windows of Lori Vallow Daybell's Jeep Wrangler. On September 25th, 2019, this defendant allowed Alex Cox to take her Jeep Wrangler to Dan's window tinting in Rexburg and spend $200 to tint the windows so no one could see the rear of the Jeep. Later that day, Lori Vallow and Alex Cox went to Walmart in Idaho Falls and purchased a track phone for Alex to use for the next murder. Alex Cox activated the Idaho Falls Walmart track phone on September 26th. That's when Brandon Boudreaux took custody of his children, so his soon-to-be ex-wife Melanie Pawlowski could fly to Rexburg. Melanie Pawlowski was the only person who knew Brandon's new address and was in contact with this defendant and Alex Cox. Melanie Pawlowski returned to Arizona on Sunday, September 29th. Again, continuing to quote, I promise it's not much longer. On September 30th, this defendant Googled, quote, how to get the backseat out of the back of my Jeep Wrangler, and watched a YouTube video on how to remove the rear seat of a Jeep Wrangler. This defendant also took custody of Alex Cox's Verizon cell phone that was subscribed to him and began acting as his alibi so Alex Cox could drive to Gilbert, Arizona to shoot and kill Brandon Boudreaux. Alex Cox left Rexburg on September 30th with the Idaho Falls track phone. The Jeep Wrangler was seen on a license plate reader in Arizona on October 1st. The rear tire had been removed. On October 1st, Alex Cox used his Gmail account to search for an address in Mesa and to search for directions to Brandon Boudreaux's rental home. While Alex Cox was preparing to commit the murder of Brandon and Gilbert, the defendant rented a storage unit in Rexburg to store the rear seat and tire. Video from the storage unit shows Lori Vallow and Chad Daybell putting the tire and rear seat into the storage unit on October 2nd. On that same day, the defendant attempted to provide a fabricated alibi for Alex Cox. She used his phone to call her cell phone. Both phones were using the same cell tower in Rexburg. The call was at 8:02 and lasted approximately 24 minutes. Meanwhile, the Idaho Falls Walmart track phone was utilizing cell phones around Melanie Pawlowski's home in Gilbert before utilizing cell towers in the area of Brandon Boudreaux's rental property. On the morning of October 2nd, 2019, the Idaho Falls track phone and Lori Vallow's Jeep were outside Brandon's home for more than an hour waiting for Brandon to return home. Brandon returned home at 9:13. He immediately saw a Jeep Wrangler with no rear tire and Texas plates. As he was slowing down, he saw the rear window lift up, a rifle barrel appear, and then he heard a bang, and his window shattered. The defendant's co-conspirator, Alex Cox, missed killing Brandon by a couple of inches. Brandon Boudreaux drove off and eventually returned to his rental property. Alex Cox drove off and back to Rexburg. On October 3rd, Lori and Alex went to the defendant's storage unit, removed the tire and rear seat, and put them back in the Jeep. Tammy Daybell was killed just a little over 2 weeks later. Chad Daybell was the beneficiary of her life insurance. Her death was later ruled a homicide. On November 5th, Lori and Chad got married in Kauai. I'm kind of summarizing here now. On February 20th, she was arrested in Kauai, brought back to Idaho. Tylee and JJ's remains were found on June 9th on Chad Daybell's property. Tylee's remains had been dismembered and burned. JJ Vallow's body was duct taped and buried in plastic bags. On May 12th, 2023, Lori Vallow Daybell was found guilty of multiple counts to include the murder of Tylee Ryan, JJ Vallow, and Tammy Daybell in Fremont County. On the 31st of 2023 of July, she was sentenced to multiple counts of life without the possibility of parole. On April 22nd, 2025, she was found guilty of conspiracy to commit first-degree murder on Charles Vallow here in Maricopa County. And on June 12th, 2025, Lori Vallow was found guilty of conspiracy to commit first-degree murder of Brandon Boudreaux. Whew, you got all that? That was 8 pages of background on this case for the judge to consider when he's handing down her sentencing order. Trina Kay goes on to list the aggravating factors. I won't go through all of those. And then she says, in the summary recommendation, the sentence for conspiracy to commit first-degree murder, a Class 1 dangerous felony, is life with the possibility of release after 25 years. The court may run the sentences for both cases concurrently or consecutively to each other. The court can also run the sentences concurrently or consecutive to her convictions in Idaho and in Fremont County. Both conspiracy to commit first-degree murder cases have multiple statutory aggravating factors. Each case has its own victims, and each case has caused and continues to cause irreparable emotional harms to the victims and their families. The state respectfully requests that this court run the cases consecutively and to each other and run both of them consecutively to Idaho. So whatever the judge sentences, they're saying, please stack them up against Idaho. Lorie then could have 7 life sentences if the judge sentences her to life in prison tomorrow. She's got the 3 in Idaho. She got 5 in Idaho, along with the murders and the conspiracies. Conspiracy to commit JJ, Tylee, Tammy. Murder JJ and Tylee. And then if she gets the conspiracy for Charles and Brandon, that is 7. So that is what the Trina K's recommendation is. Now, I want to take a minute and show you the times that Lori Vallow Daybell was found guilty and her reactions. First, we'll start with Idaho, then we'll do Charles Vallows, then Brandon Boudreaux.
In regards to count 1 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception? Answer, guilty. Question number 2. In regards to count 2 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of first-degree murder of Tylee Ryan? Answer, guilty. Question number 3. In regards to count 3 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of conspiracy to commit first-degree murder of Joshua Jackson Vallow and grand theft by deception? Answer, guilty. Question number 4. In regards to count 4, the amended indictment, is Lori Noreen Vallow not guilty or guilty of first-degree murder of Joshua Jackson Vallow? Answer, guilty. Question number 5. In regards to count 5 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of conspiracy to commit first-degree murder of Tammy Daybell? Answer, guilty. Question number 6. In regards to count 7 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of grand theft? Answer, guilty.
I'll ask the clerk to read and record the verdict.
In the Superior Court of the State of Arizona in and for the County of Maricopa, State of Arizona versus Lori Daybell, CR 2021-001704-001, verdict, count 1. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Daybell, as to the crime of count 1, conspiracy to commit first-degree murder occurring on or about July 11, 2019, guilty.
In the Superior Court of the State of Arizona, in and for the County of Maricopa, State of Arizona versus Lori Daybell, CR 2022-001242-001. Verdict, count 1. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do find the defendant, Lori Daybell, as to the crime of count 1, conspiracy to commit first-degree murder occurring on or about October 2nd, 2019, as follows. Guilty. Signed, foreperson.
So those were the jury verdicts on these 3 cases. Lori has filed an appeal in Idaho for her case there. In fact, her team finally this year, about a month or 2 ago, we did a whole Courtroom Insider on it, filed their appeal. Now the state has time to respond. They've asked for an extension, and so they'll extend that out. It might take a couple months to respond, and then they'll kind of go back and forth. So the appellate process is underway for her there. After tomorrow, the appellate process will likely begin here in Arizona, but she will not stick around to see that. She is Idaho's inmate, regardless of what happens. And I don't think Maricopa County wants to pay very much longer for her to be here. I think they want to get her out of here. Kroberger was transferred last night. I'm sorry, I keep hitting this. I'm just using my computer today. I don't have the fancy camera set up. But Koberger last night, within hours of being sentenced in Ada County, was a Department of Correction inmate in Idaho. They moved him very quickly, and I would imagine Lori will take a little bit more time. When they moved her from Idaho to here, they drove her, and it was on a random weekday. In fact, they released this video. You remember this? When she was booked into Maricopa County, just to kind of say she's here. and then they held a news conference after. I don't expect any of that from Idaho. We'll get a new mugshot from her, and boy, have we seen plenty of mugshots. These are the mugshots over the years. I mean, I've never covered somebody that's had this many mugshots. Chad has had 2, Fremont and the prison. That's it. Lori, she had the first one in Kauai, then she had Madison County, then she had she went to the psychiatric hospital. She came back and got another one in Madison County, and then she got one in Ada County before her trial, and then she got one in IDOC, the prison. And then she got one in Maricopa County. Oh, but before that, when she was sent back to Madison after sentencing, she got one there. Anyway, I've lost track. But there's all the mugshots that Lori Vallow Daybell has had. So that is where we stand there. Now, I do want to read one other document. Remember, Lori asked for a new trial? It's been denied. Judge Boreski issued this the 21st, so 3 days ago. He said, the court has received and reviewed the following: the defendant's motion for a new trial, the state's response to her motion for a new trial, and the reply to defendant's motion for a new trial. The defendant's motion argues 3 separate areas she believes warrant a new trial. This is short compared to what I just read to you. First, the defendant argues she suffered a due process violation by being made to proceed to trial when she was too sick to do so, and the court further violated her rights by seeking a new allegation regarding the extent of her illnesses that were not part of the record during the course of the trial. The issue was resolved during trial, and the court has not been presented with any new reliable evidence indicating the defendant's illness negatively impacted her ability to proceed with the trial. The record and observations of the defendant's physical appearance, questioning of witnesses, and arguments to the court and jury all evidence the opposite, that she was able to proceed with trial. The second point raised by the defendant is an allegation that the court lacked impartiality because of the court's evidentiary rulings. The defendant first argues that evidence of impartiality exists because the court sustained 2 hearsay objections from the state when the defendant attempted to cross-examine police officers about statements made by neighbors. The defendant's own motion establishes that these are the very definition of hearsay statements. When ruling in evidentiary issues, there is no rule or case law that requires the court to allow a response from the opposing side. The defendant argues in her motion that one of the statements was not offered for the truth of the matter asserted, different descriptions of the vehicle, but for the effect on the listener. The defendant never articulates what effect on the listener the statement would have had. The defendant also never articulates how, if that statement came into evidence and it was not actually offered for the truth of the matter asserted, which appears to be the only reason the defendant wanted the statement entered into evidence, it would have changed the outcome of the trial. The defendant then argues she was unable to admit several exhibits and she could not effectively cross-examine witnesses regarding Melanie Boudreau. These are, again, basic evidentiary issues which were ruled on during trial. Just because the defendant does not agree with the court's rulings does not mean she's entitled to a new trial. I think we've heard that before from this judge. The defendant never articulates how or why the court's rulings were wrong or how the rulings constitute a due process violation. The third area of argument is titled Abuse of Discretion. She argues 1, that she was entitled to a Rule 13.5 hearing on aggravators. 2, the court did not release the jury from the admonition on the record. 3, the court erred when allowing scientific evidence regarding GSR and DNA to be presented to the jury. And 4, she was denied a right to confront witness Latchchick. The first 2 points in no way have anything to do with how the jury viewed the evidence or deliberated, therefore would not be basis for a new trial. The court ruled on 13.5 request, which is essentially moot given the fact the defendant chose to stipulate to the aggravators rather than have the evidence be determined by the jury. The defendant is correct that the jury was not released from the admonition on the record, but there's no rule or case law requiring the jury to be released from the admonition on the record. The court did go back to the jury room and release the jurors immediately following the defendant's admission to the aggravating factors. Side note, I do remember the judge didn't release him and I thought, oh no, is that going to cause an issue? But it sounds like they legally don't have to. He did privately, but not on the record. Again, the defendant never articulates a reason why this would entitle her to a new trial. The defendant's argument about DNA and GSR evidence seems to be more of a chain of custody or a foundation argument rather than the substantive argument about the reliability of the evidence. The defendant's reply for the first time mentions the evidence being, quote, junk science, but she never presented any actual evidence or authority to establish the evidence was not reliable. Moreover, if there were questions as to its reliability, a competent and thorough cross-examination could have revealed those issues for the jury to consider. Although the state chose not to call the person who actually collected the evidence Latchchick, the state satisfied the foundation requirements to admit the evidence through Detective Pillar, who was present during the collection of that evidence. The reply also alleges hearsay statements from Latchchick were allowed into evidence but does not state what those hearsay statements were. It is the court's recollection that no statements of Latchchick were offered or admitted. Finally, the court in no way precluded the defense from investigating this witness, as the defendant alleges, and in fact, the defendant could have subpoenaed and called this witness if she wanted to question this witness. The defendant fails to establish any due process violation which would warrant a new trial in this matter. It is ordered denying the motion for new trial. So, Lorie is not getting a new trial. Okay? I know you were worried about that. That's not happening. What is happening is tomorrow we will gather at the courthouse at 9 a.m. Now, many of you are hoping to come, and you've asked me what time should you get there. I don't know what to tell you. I know that there will be many victims there, family members there. I don't know how many public seats there will be. I've been told there will be a media row again. We'll be on the back row. I'll probably get there around, the courthouse opens at 7:30. We'll probably get there around 7:30, maybe a little earlier, so I can, if you're in line, I can, say hi or whatever. And then at 9, the court will begin. We will be streaming it, not live. We'll have a 5-minute delay. So you can watch on the East Idaho News YouTube channel. We're going to start the live at 8 o'clock Mountain Standard Time, which right now, all of the Mountain Zone is in daylight time except Arizona. We're in Standard. So that is 9 o'clock Idaho time, Mountain Time. So, got that? Just go to our YouTube channel. If you haven't subscribed and hit the bell to get notifications, you'll get alerted by that. Go to our YouTube channel. You can watch it on a 5-minute delay. The judge, most likely this is what will happen. If you watch the Kohberger hearing this week, this is going to be just like it, almost. The judge will come in, welcome everybody. The victims will then read a victim impact statement. I imagine we will hear from Kay Woodcock. Now, before I get to that, let me tell you what a victim impact statement is. It is a written or oral account provided by the victim of a crime that describes how the crime has affected them. It's a way for victims to share their experiences and impact of the crime with the court, often during sentencing. These statements can cover physical, psychological, emotional, and financial consequences. There are certain things judges will not allow into victim impact statements in certain cases. What we heard yesterday in Kohberger, I have never heard when Xana's sister Olivia and her father turned Kaylee Gonzalez's sister and dad turned the podium and addressed Kohberger. A victim impact statement, technically you're addressing the court. You are addressing the judge. You're saying how this has affected you. You're not addressing the defendant. Now, is there a roundabout way you can? Absolutely you can. And address them in a roundabout way. But you're not supposed to go up there and say, Lorie, you this, you that, you that. And that was an issue in Idaho. The Judge Boyce, there were certain things that couldn't come in and allowed in. Now, Judge Hippler in Kohberger, I don't think he was going to stop everybody and be like, hold up, you can't say that. He did let it slide, and I don't think anybody faults him for that. Also, he let the applause happen. A lot of judges would say courtroom decorum, you can't applause, you can't show anything. He let that slide. And I'm not saying it was bad or good. I think it added to the moment, to be honest with you. But so tomorrow, victim impact statements, we'll likely hear from Kay. Kay spoke at Lori's sentencing in 2023, which the dates are so ironic to me. Do you remember this day? People camped out the night before. I remember it was a Sunday, July 30th, nearly 2 years ago to the day when Lorie was sentenced here. People camped out. I was out there live. I did a Courtroom Insider live from the lawn. Here's a clip of it. It is almost 10 o'clock, 9:45. I'm out here at the Fremont County Courthouse, and we are live with I don't know, 40 or so people, 50 or so people who are waiting in line to get into the Lori Vallow Daybell sentencing. Oh, I look so young. Anyway, that was that night at the courthouse. I did not camp out, full disclosure. I paid some friends' kids $500 to wait in line for me so I could go sleep at the hotel. Sorry, I just full confession to you. And then I arrived early the next morning and we swapped seats. But we went into the courthouse. Not everybody got in. A fraction of those people got in. And Kay Woodcock did address Lorie at that time. Here's a little bit of what Kay said.
Lorie is undeniably a monster that has not taken any responsibility or shown an ounce of remorse for her vile actions. She deserves to never again breathe oxygen as a free member of society. Her actions, dismissive behavior, and disinterest in court proceedings continue to validate her lack of accountability and remorse or any possibility to be rehabilitated. We firmly believe that she has zero mental illness that drove her to commit these heinous acts. Rather, she is driven by her greed and need to be the center of attention. During the trial, a jail call was played between Lorie and her son Colby as she continued her manipulation. Today, it feels especially poignant. Quoting Lorie, "They have made all these judgments. They think they know what happened. They think they know who's responsible. They think they know everything, but you don't know because you weren't there. And one day you will know. One day you will know what actually happened." Those are her words. It is the one truth that Lorie has told since the beginning of her campaign of terror. We do know what actually happened and who is responsible. Lorie. Today is the day that she will finally be punished for her manipulation, cruelty, and criminal acts. She has shown no remorse for the murders, the lying, the deceit, or the pain. During the trial, we heard Lorie deflect and minimize her sister's grief. We heard her exclaim that she was trying to go on with life, that she needed to be happy, all while she was dancing on the beach and her children were buried in Chad's backyard. Only someone with no remorse tries to justify the cold-blooded murder of her children with her needs. We wholeheartedly believe she was not only complicit, but was an active participant in both JJ and Tylee's murders. We believe there should never be a reason for her to be released from prison. She deprived JJ, Tylee, and Tammy of that right and should never be given what she so easily took from them. I'll leave with two final numbers. 3 for the 3 people who were murdered, who we will never forget. And finally, the number 1 for the defendant, the person that will never matter again once we walk out the door.
And Kay will speak tomorrow. She told me that she knows what she's going to say, but she's not sharing it. She hasn't shared it. She said, "I'm not going to share it with anybody." So I don't know what she's going to say. We'll also hear a victim impact statement from Brandon. This is the first victim impact statement he will give. Colby Ryan has said he wants to speak at the hearing. Unfortunately, Colby has had health issues this week. Hopefully, Colby, we're thinking about you. You can find out more about him on his channel, but I spoke with him and I hope he'll make it. He could give a victim impact statement, and there could be others. Charles Vallow's sons could show up and read a victim impact statement if they desire. Other family members could and will show up and give a victim impact statement. So that's kind of what will happen. After that, Lori Vallow will have a chance to speak if she chooses. Kohberger did not. Lori definitely did in Idaho. You need a reminder? Here's a clip.
Jesus knows me, and Jesus understands me. I mourn with all of you who mourn my children and Tammy. Jesus Christ knows the truth of what happened here. Jesus Christ knows that no one was murdered in this case. Accidental deaths happen. Suicides happen. Fatal side effects from medications happen. I have a different perspective in life because in 2002, when I was pregnant with Tylee, I died in the hospital while in labor with her. They tried to stop my labor. They put me on the table and they put something in my IV, and I felt my spirit falling to the floor. I was standing near my pregnant body, watching the doctors try to revive me, which took them a few minutes. In that time, my sister Stacy was standing to my left. I turned to hug her and was surprised that her spirit was as tangible as a physical body, because I knew I was in spirit and she was in spirit. She said she needed to show me some things, and we went to heaven. I later returned to my body. Because of this experience, I have access to heaven and the spirit world. Since then, I have had many communications from people now living in heaven, including my children, Tylee Ashlyn and Joshua Jackson, my sisters, Stacy and Lolly, my aunts and my uncles, and my grandparents. I have had many communications with Jesus Christ, the Savior of this world, and our heavenly parents. I've had many angelic visitors have come and communicated with me and even manifested themselves to me. Because of these communications, I know for a fact that my children are happy and busy in the spirit world. Because of my communications with my friend Tammy Daybell, I know that she is also very happy and extremely busy. I have always mourned the loss of my loved ones, and I have lost many in this mortal world. However, I know them more than most people. I know where they are now and what they're doing. I know how wonderful heaven is, and I'm homesick for it every single day.
Will we hear that sort of stuff again tomorrow? I imagine we may. So that is where we stand. Now, after that, the judge will hand down the sentence. Some judges are very short and to the point. Some judges elaborate a little bit. You remember Judge Boyce? He chose to elaborate. Here's what he told Lorie in 2023.
Murder is the most serious offense. And the most unimaginable type of murder is to have a mother murdering her own children. And that's exactly what you did. You were involved in and guilty of conspiring to murder another group of children's mother, Tammy Daybell, who had children of her own. And despite the jury convicting you with overwhelming evidence, you still sit here before the court today and said you didn't do it. You came here to East Idaho, where I've spent my life, and moved here from another place already with plans in progress to make your children disappear. The evidence bore that out at trial. You removed your children from their home in Arizona, alienated them from friends and family, got rid of JJ's service dog. You moved to Rexburg, a community where you could find 1,000 random families to take your children, and you brought them here to murder them. You had so many other options. You could have gotten divorced. You could have found someone to take care of those kids. But as the state was able to prove at trial, you chose the most evil and destructive path possible. You killed those children, according to the state's theory, and I believe it, to remove them as obstacles and to profit financially. You justified all of this by going down a bizarre religious rabbit hole, and clearly you are still down there. While you were enjoying your new life in Hawaii, countless law enforcement officers, family members, and volunteers were searching for your children. And I don't think to this day you have any remorse for the effort and heartache you caused for others who looked for your children when you knew where they were and knew they were dead.
Now, I imagine Judge Boreski will say a few things. Can I say that I kind of hope he does? She has definitely grinded on him during this trial. We'll never forget this moment. In case you're new here, this is the moment that I think we'll never forget. I remember it was a Friday morning, and I'm like, oh, we got to go to court on Friday. And boy, that was a fiery moment. But here's what happened that day.
Okay.
Just, Your Honor, that again, the state did raise any issue of character evidence under 404A and 405, that if the defendant opens the door and tries to advise that she's a good person, a peaceful person, a kind person, a loving person, any of those other types of things, that we believe that would allow us under 405 to then bring in specific acts such as the murder of her children, her husband, and her current husband's wife.
All right.
Which would also be 404B that they withdrew.
No, it'd be
Yeah,
405.
they withdrew it, but if you bring up 404 that
Then all 404B is in, or do we get a hearing on what 404B can come in? If I open the door, do I get a hearing? We stop trial and I get a hearing on.
Stop. We'll have a very short hearing, okay? If you're going to introduce how you have great character and good character, we're going to have a short hearing on what evidence that they can bring in to rebut that character, which could
Okay.
include being convicted of 4 murders.
And
So,
would you
talk
like?
to your advisory counsel during the break. And
You don't need to yell at me either.
yelling at you, okay?
Yeah, you are, and you do not need to talk
Okay,
to me that way. I'm
take
very
her out.
courteous.
Take her out.
I'm very courteous to you.
You're out. No, you have been nothing near courteous to me during the course of these proceedings. Talk with your advisory council about the rest of your cross. We're going to resume in 15 minutes.
All rise.
So Judge Boreski has not said much to Lori. I mean, he has, but he's kind of been restrained. But when he issues the sentence, he can say whatever he wants. He could say a few words. He could talk for an hour, whatever he wants to say. And then he will issue the sentence. And then after that, he will remand her likely to the custody of Maricopa County, I guess, not the Arizona Department of Corrections, because she's going back to Idaho. So I guess she'll go back to Maricopa unless they walk her out the door and off she goes. I don't know. We'll see. And that'll be that. We'll see after if family members decide to speak. Regardless, we'll be out there. I'll be out there doing live coverage. And of course, we will be back here tomorrow night with Courtroom Insider breaking it all down. It is a sigh of relief that this is wrapping up. It is. I was thinking today, seeing those officers on our plane, I said to one of them, you know, it's funny because for me, this all kind of really began when I flew to Hawaii, and you guys flew to Hawaii. We weren't together. We didn't fly together, but they had flown to Hawaii to kind of investigate, and I flew to Hawaii. And now we're on the same plane. Ironically, we didn't plan it. They just happened to book the same ticket. Not a lot of flights out of Idaho Falls. And we're flying to Arizona to wrap it all up. Kind of ironic that, you know, it began with a flight and it ends with a flight. So yes, we'll break it all down tomorrow night. So I hope you'll be here at 7 o'clock tomorrow for Courtroom Insider, and we'll discuss what happens tomorrow in court. And I can't thank you enough for sticking with me these past 2 years. This started as a quick 5-minute recap session at the end of the night in 2023. Never, ever, ever would have imagined we'd be here today, 2 years later, doing these nightly broadcasts, and that tens of thousands, sometimes hundreds of thousands of people are watching from all over the world. It just blows me away. And that we would have such an incredible sponsor like newspapers.com, who has came to us and said, we want to support you, and I can't thank them, and would encourage you to support them. If you're a news person, if you're a true crime person, if you're a history person, if you're a politics person, if you're just into finding out interesting stuff, newspapers.com is the website to go to. You can research whatever you want. They have billions of newspapers pages on there from over the decades and the centuries, and you can find out a lot. It's so funny how many of you I'll see like at the store, and you'll be like, hey, on newspapers.com, I learned this, or does newspapers.com have this paper? You can find out all that. They'll give you a 7-day free trial. So you can go sign up, 7 days for free, do some research, and just thank newspapers.com for being our sponsor of Courtroom Insider and for supporting us and being with us. Okay, I know you have some questions, and we have some names, some shout outs. Here we go. Jessica Morales, thank you very much for watching. Brandon Lee, if this is the Brandon Lee who lives down the street from me, hi Brandon, good to see you. Monica Chen, Eric Whitman, Tosh Patel, Jordan Thompson, Claire Alvarez, Marcus Wynn, Lily Reed, and Samuel Brooks. Awesome. Thank you very much. And now we have people watching. This is so amazing to me. Asheville, North Carolina. I love North Carolina. One day I'll tell you, well, we used to, when we lived in Richmond, we'd go down to the Outer Banks. We love North Carolina. Boise, Idaho, Denton, Texas, Flagstaff, Arizona. Hi, Arizona. We have people watching in the Philippines, Rochester, New York, Missoula, Montana. Also love Missoula. Bozeman. Been to Bozeman. Eugene, Oregon, Pensacola, Florida, Sioux Falls, South Dakota, Santa Fe, New Mexico. Wonderful. Thank you very much. Let me get to your questions. Nate, have you spoken with Lori since your interview? I'm curious what she's doing tomorrow. Well, I got a message from Lori yesterday. We had not communicated at all since our interview. Apparently, she tells me that she got in trouble for asking me to bring her M&Ms. And so, yeah, she got her tablet taken away. And so, yeah, she got her tablet taken away. She has it now, and she can communicate. And so she just sent me an updated letter. And she's got the tablet back, and I think she's getting ready for tomorrow. I have not written her back yet, but we'll see. I don't even know what I'd ask her or what's happening. But yeah, I have communicated with her. Nate, it's bothering me. How in the world does Lori do her hair? Well, so I think in Madison, she was given scissors to cut the girl's hair, the lady's hair in the jail, and her own hair every few weeks. I don't think they allow that in Maricopa. And from what I understand, she can wet washcloths or like shirts, t-shirts or whatever, get them wet and then cause it to curl her hair. And she, was a hairdresser as a professional, and so she knows these things. And then the other question you're going to ask is makeup. And how does she do her makeup? Candy, Jolly Ranchers. Some of you said maybe that's why she wanted the M&Ms to do her makeup. I don't know about that. You can take a colored pencil and do that. So yeah, that's what I know about that. Okay. Here we go. Nate, do you really think Lori will speak at her sentencing? I think she will. I do. I really think she will. I don't think she can help herself. And I don't see her sitting quiet. She might shock us all and sit quiet, but I'm not sure. So what was the cause of the death of Charles Vallow, Lori's fourth husband, and who admitted to the shooting? Well, originally Alex Cox admitted to the shooting and said it was self-defense. And it turns out that it was not self-defense. The cause of death now was, or the manner of death was homicide by gunshot wound. I don't remember the specific medical terminology for it, but yeah, that is how he died. What role did Alex Cox play in the events leading up to the Arizona charges? Why was he never charged after the shooting? It just seems ridiculous that he wasn't. That's a good question. I mean, what role did he play? He obviously was in on it. He went to the house, spent the night, had his gun, waited for Charles, shot Charles not only once but twice when he was standing and then when he was on the ground, and then came out and said that he had hurt his head. There was no blood anywhere in the house. I mean, they really went through all that. I don't know why he was never charged. The crime happened in July. He died in December. That's 5 months. I don't know. Now, I've been told he was always under investigation. So he was always under investigation, but he was never charged. And I'm sure if he were alive today, he would be looking at a similar fate of Lori or Chad, or a lot of people think he would have flipped and turned on one of them. What was Lori's reason for moving Charles Vallow's belongings shortly before his death? Moving his belongings. I don't know what you mean. If you mean... Well, he had moved to Texas. She wanted to move back home, so he rented her a house. And I don't know if they ever moved belongings. I'm not sure how to answer your question, but she I guess she took his truck. She was doing some shady stuff, but I'm not sure. Nate, what does Melanie Boudreau say about all of this? Melanie Pulowski, will she be at court? Do you think she'll ever talk to you or do an interview? I don't know. I'd love to talk to Melanie. I don't know what she thinks about all this. I would imagine she has a story to tell. And I would imagine she's just trying to focus on, raising her kids and being out of the spotlight. She is under investigation. They have said that. Will she be charged? That's the question. Rachel Smith, the veteran prosecutor, told me here on Courtroom Insider she does not think Melanie will be charged. Well, I guess she didn't flat out say I don't think it will, but she said that she's never seen a prosecutor go after the main person like a Lorie or a Chad, and then after they're convicted go after minor people. Normally you might go after the minor people and then go after the major. I'm not saying I have an inside track at all. I have no idea, but we'll see. And maybe Melanie will decide to talk one day. How did Lori Vallow react when police informed her of Charles Vallow's death? Sorry, I'm new to the case and just getting caught up. Well, she acted like she already knew. They went to tell her inside the van. She was waiting inside a police van with Tylee. They went to inform her that her husband had died. And she said, yeah, we already know. And it was very unusual. And the cops were like, what? What is this? And then they drove her to the police station. And that's where just the unusual interviews continued with Lorie and her attitude. And then in the car, she was acting very odd. So yeah, she didn't act surprised at all. It was just normal Lorie. What's the significance of the Ring doorbell camera footage in the Chandler police investigation? There was one Ring doorbell that happened that a neighbor caught, and this was 2019. I get all my years confused. So the technology was not as good as now, and fewer people had doorbells back then compared to now with cameras. But one camera did catch the Tesla, Brandon, when he was returning home. It turned and it caught the bang, the loud bang, and they played that in court. And it was loud and it caught the gunshot. And that was the gunshot of Alex firing it out of the back of the Jeep at the Brandon's car. So, yeah, good question. We have that on our YouTube channel if you want to see it. Nate, does Lorie have access to the Book of Mormon, to the Bible, and other scriptures? I asked her that one time. Let me see. She said, yes, I have scriptures, but no Bible dictionary or topical guide, which I miss. You can learn so much from the Bible dictionary, things you never knew. So she has the Bible, but not the Bible dictionary or the topical guide. Sorry if you just heard that noise. Jordan, photographer extraordinaire, his room is next door, and he's sending me a file that I need for East Idaho News. I think those are all the questions we have for tonight. I know you might have a bunch tomorrow. We'll be back, of course, tomorrow. I'll be here again with you for Courtroom Insider. And then we'll see. I know I also have an interview request in for Trina Kay. I'd love to talk to her. We'll see if I end up getting any interviews this weekend while I'm here in Phoenix. And if so, we'll have some Courtroom Insiders next week that you can tune up on. But tomorrow we'll focus on the sentencing and what happens in court. Here's where you can find me. I'm on Facebook, Instagram, X, and YouTube. Thank you very much again for supporting us, for following us, and for just being here. And tomorrow morning, tune in. I think Jordan and I will go live on the way to court, so you'll catch a final live on the way to court. Will we get donuts is the question. If we don't get donuts tomorrow, maybe we'll do it on Saturday, because we're going to be here Saturday too. So either way, one more donut run. One more at least. And I know you all love the donut runs. And for those of you that are new here, like, what the crap is he talking about, donut runs? You'll just have to watch. Do not miss it. Boom, boom. All right, everybody. Thanks for watching. Go to bed. We'll see you bright and early in the morning. This is Courtroom Insider. I'm Nate Eaton. Have a good night.